Well, I hope this is a really short one. I was talking to someone today, and we were talking a lot about a lot of different laws. But when I mentioned ethics, he wasn't sure what I was talking about. Well, look there's supposed to be ethics in politics, but there isn't. Some politicians are highly ethical. Quite a few, are highly unethical. Spreading disinformation, misinformation. There's also ethics in the media. See, all you got. I've been trying to encourage people to sometimes when people talk, when you're watching the news, podcast or whatever, or seriously, all you got to do is look up what they say. Okay, ethics violations. Okay, ethics violations in politics. That's always happening. Ethics violation in government contracting. Ethics violations examples. Ethics violations in the news, which happens a lot. There would be some people that couldn't be on the air if they were actually charged with those ethics violations. Ethics violations in the government. Ethics violations in the workplace. And you could quite literally file charges. Well, workplace ethics violations include a wide range of misconducts from minor infractions like lying or wasting time to serious offenses like harassment, discrimination, theft, and financial fraud. These violations can damage a company's reputation, morale, and financial health, and can include issues like conflicts of interest, dishonesty, safety violations, and misuse of company property and information. Common examples of workplace ethics violations are harassment and discrimination, bullying, unwelcome advances or biased treatment in hiring, promotions, daily interactions, dishonesty, lying on timesheets, falsifying documents, stealing or misrepresenting information about products and services, in which a lot of companies do. They call it corporate puff, meaning they will lie about a product or embellish, as they say, over exaggerate the potential of a product. They will lead you to believe that, like that self-driving thing on the electric cars, that it still doesn't work. But a lot of people made a lot of money selling that idea. Some shareholders, or when people invested in that, they the profits they made wasn't the expected outcome, which was, it wasn't anywhere near what they were told they would make. So they sued the company, but the judge said, no, you should know better. That's just corporate puff. Everybody knew the guy was exaggerating. So but that's not in the public interest. If you remember, I did a video on the legal obligations of doing what's in the public interest. Okay, which everybody in the public service is legally obligated to do what's in the public interest, because the oath requires that they serve and protect we the people. That's the Constitution was written to serve and protect we the people from unruly servants. Misuse of company resources, using company time and technology for personal activities, or stealing office supplies or merchandise. That happened a lot where I worked at. Confidentiality breaches, theft, taking company property, safety issues, safety violations, financial misconduct, intimidation, and disrespect, verbally intimidating a coworker or creating a hostile environment through gossip and bullying. I was a victim of that. I took it to the Equal Opportunity Employment Commission. Went to National Labor Relations Board, the Labor Board, and they all told me get a lawyer. Okay. So remember, in the workplace, 10 unethical behaviors in the workplace. So, okay, ethics violations in politics. Ethics violations in politics generally fall into categories relating to conflicts of interest, abuse of power, and the misuse of public resources for private gain. These actions undermine public trust. If you read the public trust doctrine, you'll understand that better, and lead to civil or criminal penalties, including fines, imprisonment, and removal from office. Common types of ethic violations in politics include conflict of interest. This occurs when a public official's personal interest, financial or otherwise, could potentially interfere with their duty to serve the public. This includes situations where a government decision could benefit their personal finances or those of their family members. Officials typically have an obligation to recuse themselves from such decisions. Bribery and corruption, accepting bribes, kickbacks, or unlawful gratuities in exchange for an official act, or being influenced in the performance of official duties, is a serious criminal offense, which that also violates the basic obligations of public service. That's a lot of laws that are being broken. They're in the basic obligations of public service. Misuse of a position or resources. Public officials are prohibited from using their official authority, title, or government resource, such as staff time, government vehicle, or email systems, for personal gain or campaign political purposes. Misuse of confidential information, using non-public information acquired through an official position or personal financial profit. Insider trading is a significant violation of ethic laws. Nepotism and favoritism, hiring family members or close associates for government positions based on personal relationship rather than the merit, is considered an abuse of power and ethically wrong. Hatch Act violation. The Hatch Act restricts the government activities of federal executive branch employees to ensure that government functions are not impacted by partisan politics. Violations including using one's official title when engaging in political activity, soliciting political contributions, or using official authority to influence an election. Revolving door issues. This refers to movements of officials between government jobs and private sector, lobbying or consulting positions. Restrictions are often in place to prevent former officials from using their past connections and inside knowledge to unfairly influence government decisions for personal gain. And that is also violating the basic obligations of public service. People, look that up. Basic obligations of public service. Enforcement of these laws and rules is carried out by various bodies, including the House Ethics Committee, the Office of Government Ethics, OGE, the Office of Special Counsel, OSC, and the Department of Justice. The public and the watchdog groups also play a role in monitoring and reporting potential violations to ensure accountability and maintain the public trust. People, so these are government agencies that know this is going on, but they ain't gonna do nothing until you drop a dime. All right. I know, ratting them out, snitching, telling, come on, people. These are your servants that are supposed to be doing what's in your best interest, but they're doing what's in their best interest, what's in for their own personal gain. I'm not saying all. But we know there's a lot of politicians out there doing that. I was talking to this young man, and we were talking about the situation of the government, and I explained to him we're a corporacy. Quite literally, by definition, we are a corporacy, or a corporacy, which is a government ruled, government under corporate rule. Okay, all decisions, laws, etc., based on financial interests of corporations. Look it up, corporacy. I also did a video on that. It was done in Europe in the 1930s, 40s. They tried it here in the 30s, 40s. It's called the Washington Putsch, Putch. That was during a Roosevelt's administration. And but look it up, corporacy. Okay, so ethics violations in politics, in the workplace, government contracting, in the news. Recent news includes a South Jersey school board member suing state officials over free speech limitations on school matters. The U.S. Department of Justice continued to pursue the case involving corporate fraud and bribery and reports of ethical failures in government and corporate settings. Such alleged human rights abuses in supply chains and the misuse of government resources, politics, and government. Okay, so remember, you can always file for ethics violations. People, nobody's gonna do nothing without the red tape. That's what they used to call it back in my day, in the 60s, 70s, I think 80s. I don't know if they still call it red tape, but you have to file a complaint. They know about these ethic violations. They watch the news as much as we do. They use the internet as much as we do. Who doesn't have a handheld device? When I was young, we didn't have that. You know. But you should take advantage of it now. Okay, ethics violation government. Oh, for lawyers. Lawyers are expected to adhere high standards of professional conduct, governed by rules typically adopted by state Supreme courts, based on the ABA model rules of professional conduct. If you remember my other videos, I told you that I often use the ABA model rules of professional conduct because some of the states have excluded, omitted, just basically left out some things that are in the ABA model rules of professional conduct. Model rules of professional conduct are the standards set forth for every state, and they can't leave anything out. You know, they can add to it to give it strength. You know, and taking away from it for anything from it that's in the interest of the bars is strictly forbidden, which they have taken things out, and I've discussed that when I discussed the rules of professional conduct before. Client-lawyer relationship, negligent, and lack of diligence. Diligence is a requirement for all lawyers. It's in the rules of professional conduct. Failure to be diligent is breaking the law in a court of law. Failure to act with reasonable diligence and promptness in representing a client or neglecting a client's case, e.g., misusing a statute of limitations or a court date. I was telling people about quick and speedy trial, the limitations on that, which is also often exceeded. So look up wherever you're at, just look up quick and speedy trial. You'll see the limitations. I've seen people wait years to go to trial without any knowledge that if that trial didn't happen within a limited amount of time, it could have been tossed. They could still have that case dismissed based on the fact that they did not have a quick and speedy trial, guilty or not. They could be sitting on death row. And because they didn't have a quick and speedy trial and nobody told them about it, and informed consent is required before any proceedings can move forward in a court of law, and the lack of informed consent is the lack of effective assistance of counsel, which is deprivation of rights. That's a whole lot of law breaking there, my friends, all right? I'm just talking to you from the heart here, okay? I'm not trying to sound like a lawyer, because I don't speak lawyer. You know, I'm just a layman like you, but I know a lot of laws. And I'm reading them to you, word for word to the letter, as required by law, because the penalties behind violating the letter of law are stiff and stern. Penalties include fines, removal of public service, and incarceration, and if death is involved, one can receive the death penalty. Okay, I'm just Look it up. It's on the net. Okay, I did a video on that. I'm sorry if I sound a little upset. It's because it's happening to all of you. No matter where you're at, no matter what state, no matter what court. It's rare. Ask yourself, if you ever needed a lawyer for anything, have they ever spoke to you about their legal obligations? The legal obligations of all lawyers and judges, not just to you, but to the public in general. The Sixth Amendment guarantees effective assistance of counsel. Effective assistance of counsel is described in the Rules of Professional Conduct and the Code of Judicial Conduct. Any violation of either or it not only shows ineffective assistance of counsel, but the ineffectiveness of the court in its entirety. Failure to communicate. Communication is mandatory. It says so in the Rules of Professional Conduct. It says communication. Failure to communicate is breaking the law. Okay. Not keeping the client reasonably informed about the status of their case, failing to explain matters sufficiently. Again, the informed consent for them to make informed decisions. Informed consent requires reasonable knowledge to make an informed decision to give such informed consent, and you lack that. It was never given to you. It was never explained to you. Reasonable question for breach of confidentiality, disclosing information related to the client's representation without their informed consent, except in rare specific instances. Remember that. Breach of confidentiality. Disclosing information related to the client's representation without their informed consent. And I was talking to the kid the other day about his case. Nobody mentioned anything about a quick and speedy trial, and they spent almost a year trying to convince him to take a cop out. He wouldn't take the cop out. He wanted a trial, so they didn't have to go to trial because he wanted to pick his jury. They threw the case out. They were even over a motion to quash, but he didn't know what that was, so he turned it down. If they would have let me speak for him, which they wouldn't because I'm not a lawyer, but if I had the chance to, I would have told him, hey, take the motion to quash. That means it's over and done with right here, right now. And but they threw it out. They didn't want it to go to trial because they had no probable cause. And that's what he was really upset about, because when he asked for a probable cause, the judge at that hearing said, oh, I know where this is going. This is going to trial. The public defender asked a couple of softball questions, so the judge sent it off to trial from 51st and Wentworth to 26th in California. And it was almost a year before they threw it out. Talk about a time of wasted resources, time and resources. But it's common cause. It happens quite often, and I've been to several different states just to witness it. My younger days, sometimes there would be cheap flights, parts unknown. I just needed to get out of the city, my city, for a while. I lived in Chicago. And to break the monotony, the mundane feeling of, my daily activities. So, but I always was interested to see if everything was the same all over, and it was. Nobody abides by the rules or the codes. Anyways, when I told the kid about the probable cause hearing, and then I told him about asking for, telling me you want a quick and speedy trial then. And they violated that. And at no point did the public defender even try to help. All the public defender did was try to convince the kid that I was nothing but a jailhouse lawyer. I didn't know what I was talking about. He's going to get convicted, even if he picks his own jury, yada, yada, yada. Just give up, kid. Just give up. Just take the plea deal. And no matter what, he wouldn't take it. He wouldn't take it. Incompetence. Competence is a rule. in the rules of professional conduct. Failure to be competent is incompetence. It's telling you right here. Accepting a case or handling a legal matter without the necessary knowledge, skill, or experience unless the lawyer gets help from another competent attorney. But failure to abide by the rules of professional conduct, failure to be diligent, that's incompetent. Failure to communicate, that's incompetent. Failure to expedite litigation, that's incompetent. I just gave you 3 laws in a court of law and use another law, competence, to show that they were incompetent in everything whatever they did. They were incompetent in applying any of the rules, whether it be in the preamble or the scope or the rules itself. That's defective, destructive assistance of counsel. When it came to the oath they took to our beloved United States Constitution, they decimated it, they desecrated it, and defecated on it by denying you your right to effective assistance of counsel. Financial misconduct, mishandling clients' funds. That's also in the rules of professional conduct. It states specifically how they're supposed to take care. But you'll have to go into the rules of professional conduct, and they don't. People are in guardianship. What was that woman, Britney Spears, conservatorship, and nobody's ever given informed consent. Nobody's had reasonable knowledge to make an informed decision to give that informed consent. The way their money was being handled, the rules of professional conduct, if you go through it, there's a rule that specifically tells you how it's supposed to operate, and they go beyond that. Applying client funds with personal or firm funds, failing to keep complete records, or misappropriating client money. Excessive or unreasonable fees, that's also in the rules of professional conduct. Not abiding by the rules of professional conduct, actually doing contrary to what's mandatory in the rules of professional conduct, makes any fee excessive and unreasonable. Charging clearly excessive fee or failing to communicate the basis of the rate or the fee in writing where required. So you might want to ask them to itemize that bill, because they will call you to see how you're doing and charge you an hour for that 3-5-minute call. Failure to refund unearned fees, that happens to a lot of people. Not properly returning any advance payment or a fee that has been earned upon termination of representation. I got a guy out of prison in 91, Centralia. On a late notice of appeal, his lawyer took $7,500 to file his appeal, and the lawyer exceeded the statute of limitation on that, which was 30 days. So the lawyer lost his legal right to file that appeal and kept said monies. So the guy thought he lost his right to an appeal, lost his money. Felt sorry for him, Wife was there, kid, crying and stuff, So I told him about late notice of appeal. He had no idea what I was talking about, which I don't think people actually do that, But I filed a late notice appeal based on a conspiracy against rights under the color of law, and stipulated all the laws they broke, starting with the rules of professional conduct and the code of judicial conduct, and the judge's failure to cite the attorneys for violations in the rules of professional conduct, himself for the code for not reporting himself for violating the code of judicial conduct, and the countless amounts of contempt of court for every time he appeared in court, and the judge's failure to cite anybody for violating the rules or the codes. So thus, multiple counts of deprivation of rights And considering the fact that it's mandatory to report misconduct in the rules and the codes, and nobody did that, proving a conspiracy against rights under the color of law, I demanded that they be diligent, expedite that litigation, said my claims and contentions were, I had meritorious claims and contentions, but I used the rules to get, and he was out in 2 weeks. But I had him sign it, had it notarized. He signed it, had him send it return receipt mail, and he was out in 2 weeks. I also put in for an appeal bond. He didn't have the money, so it was on a reconnaissance bond, But he got his money back from the lawyer, but the lawyer should have gone to jail. The judge should have gone to jail. I never seen or heard from him after, but it's okay. It's okay. I did what I did, what I thought I was supposed to do. I didn't get paid, but I sure I'm pretty sure that kid had a big old smile when Daddy got home. All right, committing a criminal act that reflects adversely on a lawyer's honesty, trustworthy, or fitness as a lawyer, and that's not abiding by the rules of professional conduct or reporting anybody for violating, reporting misconduct for violating the rules of professional conduct and code of judicial conduct does not limit to a case they are involved in. All they have to have is knowledge of any lawyer, any judge, anywhere in our beloved country violating rules or codes. It's mandatory to report that misconduct. Assisting in unauthorized practice of law, helping a non-lawyer engage in unauthorized practice of law. Reporting a violation. If you believe a lawyer has violated ethical rules, you can file a complaint with the State Bar Association's Disciplinary Board or the Office of Disciplinary Counsel of State Supreme Court. The process and requirements vary by state, but generally require a written complaint. Okay. Rule 8.4, misconduct. Lawyers are subject to discipline when they violate or attempt to violate the rules of professional conduct. Not only assist lawyers subject to discipline when they violate or attempt to violate the rules of professional conduct, not only assist or induce another to do so through the acts of another, as they request or instruct an agent to do so on the lawyer's behalf. However, does not prohibit a lawyer from advising a client concerning actions the client is legally entitled to take. Many kinds of illegal conduct reflect adversely fitness practice of law, such as offenses involving fraud or office of willful failure to file an income tax return. However, some kinds of offenses carry no such implication judicially. Distinction was drawn in the terms of offenses involving moral principle. The concept cannot be constructed to include offenses concerning some matters of personal morality, such as adultery or comparable offenses. No specific connections to fitness and practice of law. Although a lawyer is personally answerable to the entire criminal law, a lawyer should be professionally answerable only for offenses that indicate lack of those characteristics relevant to law practice. Offenses involving violence, dishonesty, breach of trust, serious interference with the administration of justice are in that category. A pattern of repeated offenses, even ones in minor significance when considered separately, can indicate indifference to legal obligation. Discrimination and harassment by lawyers in violation of paragraph G undermine confidence in the legal profession and legal system. Such discrimination includes harmful verbal and physical conduct that manifests bias or prejudice towards others. Harassments include sexual harassment and derogatory or demeaning verbal and physical conduct. Sexual harassment includes unwelcome sexual advances, requests for sexual favors, and otherwise unwelcome verbal and physical conduct on a sexual nature. Substantive law of administration or anti-harassment status in case law may guide application of paragraph G. Conduct related to practice of law includes representing clients interacting with witnesses, co-workers, court personnel, lawyers, and others while engaged in practice of law. Operator managing a law firm in law practice. Okay, but says the lawyer may refuse to comply with an obligation imposed upon law upon a good faith belief that no valid obligation exists. The provisions. Oh, okay. Oh, this is good. Lawyers holding public office assume legal responsibilities going beyond those of other citizens. A lawyer's abuse of public office can suggest an inability to fulfill professional role of lawyers. The same is true of abuse of position of private trust as a trustee, executor, administrator, guardian, agent, and officer, director of manager of corporation or other organizations. So there's a lot of lawyers out there that are politicians. Now there's a lot of laws out there that are being made that aren't in the public interest. So you can hold your politicians that are lawyers for ethics violations, as well as violating the rules of professional conduct, as well as violating the basic obligations of public service, violating the public trust, the public trust doctrine, because the legal system is part of the public trust doctrine. So many laws being broken. All right, people. I'm going to let you go for now. There's so much to talk about. There's one kid, he wants to know everything now. Yeah, this is going to take a while. All right, so I'm going to see if I can get him to come here and sit here with me and ask me these questions. And I can answer him, same time answer a lot of you. Because I'll be honest with you, all of y'all ask the same questions. And I've done videos covering anything and everything anybody's ever asked me. And beyond that, I've answered questions you haven't even thought of yet. So if you go through my videos, you'll find them all interesting. I've always found the law interesting and quite useful. Kept me alive, kept me free. Your rights aren't a given. They are earned. I've earned mine. And I'm trying to teach you to earn yours. All those that took the oath to make sure all this happens, everything I talk about, they're the ones responsible for making sure all this happens. But they're not. So it's up to you to make it happen. It's up to you, all of you. I've been doing this for a long time. And one man alone has nearly killed me. Life's been threatened multiple times. Left me unemployed. Broke in more way than one. But if it wasn't for what I knew, I wouldn't have got Social Security. I wouldn't have got my Medicare card. I wouldn't have got my knees fixed. I wouldn't have got my wrists fixed. I'm trying to get my ankles fixed. I wouldn't have got my shoulders fixed. But they stopped there. My lawyer intentionally threw my case. Workman's comp, lawyer, Social Security, intentionally threw my case. Nobody abided by the rules, the codes. Everything they did was highly unethical. But see, it was just me using all this against them, all kinds of stuff. And they didn't like it. They didn't like me trying to get it on the record. So the only way I can get any of this and all of this on the record is with your help. You know, when it comes to we the people, you are my brother, and I've always done my best to look out for you. Some of you get upset. If this is true, why aren't they doing it? Why are you asking me? Why aren't you asking them? Why aren't you asking them? Here I am giving you their job descriptions, what they are legally and ethically required to do. I have given you the penalties, fines, removal from public service, and incarceration. But nobody's facing those penalties. Not one of our public servants, from the popo to the president, nobody's being held accountable. No King's Day wasn't about the president or just the president. It was about the rule of law. The law applies equally to everyone. Nobody above the law. Public servants are legally supposed to be held to a higher standard. But they're the ones holding each other accountable. And they ignore every standard set. So I don't care about your politics. I'm apolitical. All I'm about is the law, and I'm a stickler for it. I may not be a public servant, but when I was 10, I had an epiphany after reading the Declaration of Independence, after reading the Constitution, being in school, and reciting the Pledge of Allegiance, and realizing I wasn't pledging allegiance to a flag, nor to a government, not to the military, not to a politician or a political party, and definitely not to a corporation or corporations. When I took that Pledge of Allegiance, I pledged my allegiance to we the people. That's where my loyalties have been and always will be. A standard every public servant should live up to. If you don't mind me quoting Kazimierz Pulaski, I come here where freedom is being defended to live and die for it. May your Creator always be with you and rain many blessings. I wish you nothing but a long life and good health. Peace be with you.